Today is not a day to celebrate, but the arrest of Richard M. Allen of Delphi on 2 counts of murder is sure a major step in leading to the conclusion of this long-term and complex investigation. Of this long-term and complex investigation. Of this long-term and complex investigation. Of this long-term and complex investigation.
All right, what is up, guys? Welcome to the transparency. Want to make sure I have this documented again. Good afternoon. This is the motion that was filed after Judge Gall came out and said, hey, guess what? You guys aren't going to be able to do anything. Brian Koberger's defense team, they had to file one of these, which is the motion for the court to certify the court orders for interlocutory appeal pursuant to Appellate Rule 14. And basically, I think there's some breadcrumbs in here, so I kind of want to point them out. Richard Allen, by and through his counsel, moves the court to certify the September 4, 2024 court order. This is granting the state's motion that prevents the defense from presenting certain evidence. This is from the motion in limine. And the August 28, 2024 order denying the defense's motion to suppress certain statements made by Richard Allen. Again, the defense would request the court to rule quickly because guess what, guys? We have a trial October 14th. So in support of this motion, Allen states the following. Check it out. So basically the first couple points here, 1 through, I think it's 6. Yeah, 1 through 6. The Indiana Supreme Court has recognized, so they talk about how it has worked for the prosecution when filing a motion like this, and then and they cited a case, and then how it has also worked for the defense, and they cited a case. Okay, so letting everybody know this is not something new. They've done it from the prosecution standpoint as well as the defense standpoint. Boom, boom. So the denials of the motion to suppress are also eligible for interlocutory appeals, or the appellate review rather, citing again a case. And it brings me to my first point with that, which is number 4. The defense contends that the court's September 4th, 2024 order denied Richard Allen's right to present a defense in violation of, which would be our 6th Amendment to the United States Constitution. Again, good afternoon, everybody. I don't know what's going on with everybody just violating everybody's rights around here and nobody giving a fuck. So I give a fuck. So I'm going to talk about it. Let's see if this helps. Hey. If you guys are listening at work, hey. I think there's some breadcrumbs in here. Not only does it violate our constitutional rights, but the defense contends that the court's September 4, 2024 order denied Richard Allen his constitutional rights of the following provisions of the Indiana Constitution. So, and that would be Section 12, Section 13A, and Section 19. Section 12 is all courts shall be open, and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. B is Section 13A, which is in all criminal prosecutions, the accused shall have the right to a public trial by an impartial jury in the county in which the offense shall have been committed, to be heard by himself and counsel, to demand that the nature and cause by or of the accused against him, and to have a copy thereof, to meet the witnesses face to face, and to have compulsory process for obtaining witnesses in his favor. Really big there. Listening while driving. Section 19 is in all criminal cases, whatever, the jury shall have the right to determine the law and the facts. You guys, this is huge. And this goes to admissibility versus weight, okay? When you hear somebody say, well, if I was to object to something, and this goes more to that it's not inadmissible, but it's going to go to the weight of the evidence. So my objection would be sustained, but let the jury apply the weight to it. It's admissible evidence, okay? But it's going to go to the weight of it, and that's going to become on the jury's decision, how they're going to weigh that evidence. Same with a judge. When they have to make decisions. And that's, I think, the issue for me right here is that what the fuck is going on here? Judge Gall is basically playing the judge, the jury. She's playing every role, in my opinion, and I think that this is crazy. So, furthermore, with number 6 here, as to the alleged confessions of defendant Allen, the defense contends, remember, they're going to talk about 60 confessions, all which are different. None of those confessions were ever the same. They're different. And by textbook, I'm telling you, that is the definition of a false confession. If you're making multiple confessions and they do not resemble each other, they're different, and that they have no resemblance of the crime scene and things to do with the crime. So you do have the protections to not self-incriminate and things like that. But furthermore, as the alleged confessions of defendant Allen, the defense contends that the court's August 28, 2024 order denied defendant Allen of his 5th, 6th, and 14th Amendment rights under the U.S. Constitution, as well as his constitutional right under Article 1, Section 12, 13, and 14 of the Indiana Constitution. If the court has erred and the determination of the error is withheld until after judgment, so if we don't fix this until we go to an appeals process, okay, we want to fix this now, but if we don't, okay, so if the court has erred and that determination of the error is withheld until after judgment, which would be after a trial, then the appellant victims' families and citizens of Carroll County will suffer substantial expenses and damages as follows. So then they're going to list what's up. And A is, first of all, Richard Allen is going to be incarcerated, which is that sure liberty, that freedom. Okay. And he has to wait there to do it all. Do you know how long that's going to take? B is, this is about talking about the cost. If Richard Allen is convicted without interlocutory appeal, then he, as well as the families of the victims, would first suffer through the anticipation of a ruling from the Court of Appeals or Supreme Court on these critical issues, and then whether a reversal will result in a second lengthy trial. If the appeal in regular court, not interlocutory, results in a reversal, then Richard Allen and the victims' families will have to endure a second lengthy trial. We can prevent that. Let's try to prevent that. Hillary, the projector's out here. Also, the taxpayer. So we're talking about money. So see, like cost. So the first thing I talk about is, the freedom. With A, B, and C are basically cost. Again, we're talking about the taxpayers of Carroll County. They will suffer substantial costs, perhaps in the millions. It should already be in the millions. Attorney's fees, all the things that come along with the cost of this type of work. And it's just listing everything. Additional costs associated with sequestering a jury during a second trial would be also significant in both expense and time. And also the motherfucking people's, our time. All right. D is Moreover, the prosecution of defendant Allen has brought about worldwide attention in nearly every form of media coverage, as well as extensive coverage by various social media platforms. The disclosure of facts and information, so when this is going to come out in the trial, right? Including many facts unknown to the public even to this day. All right, so guys, guess what? There's going to be a ton of things that are coming out in this trial that we do not know about yet. At a jury trial will result in the consumption of this information by these reporting sources. Then, what are these reporting sources going to do? Then there's going to be the dissemination of the information to the public, which will be undoubtedly, it's going to occur, right? Everybody's following this case. They're commenting on it. They're reporting on it. It will make it more difficult for the defendant Allen to find an unbiased jury in the event of a retrial. We just went through all of that in the Brian Colbert case as to why you were changing venues, things like that. Defendant Allen's detention circumstances. I have no idea how they've gotten away with this. Okay. He is innocent until proven guilty, and he is literally just think about yourself. Just right now, you're driving around your car, someone pulls you over, boom, locked up, and your life changes in your 23 hours a day solitary confinement. What? How can I not have the right to be part of my defense as well? So E is all about how they were detaining Richard Allen. So he has been and continues to be isolated from any sense of normal contact with the outside world, with the exception of the ability to make monitored phone calls to his family. This has been the case for nearly 2 years. 2 years. To the extent of a retrial would occur, defendant Allen's detention circumstances would place further burdens on him and the facility in which he is housed. I know, I love these little lives. The mom of Carson Hockey. This workload would be compound and would likely require months and months to organize, review, and prepare for a second trial. Rex says nothing but that Hoosier hospitality, nothing but pure motherfucking bullshit. Absolutely. 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 We're going to get into the goods right here. So again, now right here was about his detention. Now F, we're going to get into the discovery. There was tons of discovery because this case was on, multiple agencies. So the voluminous discovery offered by the state, then they did their own depositions. So then that developed transcripts resulting from discovery conducted by the defense and mounting number of transcripts stemming from the pre-trial hearings. So think of all of this stuff. It has resulted in, copious amounts of trial preparation for both the state and the defense. If a second trial were to occur, the compounding of discovery, transcripts, and other related materials stemming from this case would place extraordinary burdens. That is a fact. This is not an opinion, you guys. This is a fact. Extraordinary burdens. We, the people, would be part of that extraordinary burden on the state, defense, victims, families, defendants. And I don't know why we're not talking about motherfucking citizens in this bitch. Not to mention the judge and court members in both Allen County and Carroll County. This is exactly kind of what Judge was talking about with his ruling on why he's changing the venue. Even if you didn't even show a presumption of being the jury is presumed to be of guilty bias, we can't even have it here because logistically we can't function. Okay. So law enforcement officers from the various investigating agencies would be required to continue to exhaust their time and resources, even beyond the 7 years that has already passed since the crimes were committed. And finally, the additional expenses to be borne by the taxpayers of Carroll County. There we go. Finally talk about us. It would continue to mount and mount and mount. It is for these reasons that an interlocutory appeal addressing the issues of defendant Allen's pretrial detention and incriminating statements allegedly made by him thereafter is appropriate. H, we're going to get into here. So everything kind of like leading up to this point where we get to H is the confession, the imprisonment, taxpayers' money cost. All right. Now we're going to get from H down. We're going to be talking about, let's talk about some logistics here. Additionally, should this court not allow these issues to be heard by the Court of Appeals in an interlocutory fashion, then during the jury trial, now this is important. Judge was adamant about this. Judge said, or not Judge, but Judge Gall said, hey, you only have so much time to present this case. All right. But she also said that you're able to offer proof, show an offer of proof at the trial to be able to get certain things in, because I'm not ruling out the third party culpability yet. But you're going to have to show offers of proof, and it's going to have to come at trial. How in the world are you going to do that and not think that it's going to take time to do that? It's going to take time that you're already not giving me to have a trial, basically, and telling me that I only have, we're going to do this in 3 weeks or a month. All right. 3 weeks or a month for something that's taken them 7 years. It doesn't make any sense. So, so then what they're arguing here is that, so additionally, should the courts not allow this appeal, right, to be heard, then guess what's going to happen? Then during the trial, set to begin October 14th, the jury will be sitting for hours. So your jury is going to be having to sit just like it's outside of the presence of the jury, just like in the Karen Reed case. You know when they would just leave for like a little bit of time? I was there in March. Okay, I was there in March and was sitting in that courtroom. And everything that basically was going on in that courtroom in March for that, the contempt, when Todd Click testified, they were going through the process of offers of proof here, voir diring, basically. And literally every other question, Nick was objecting. Relevancy, objection. I mean, it was insane. So here, Baldwin's saying that guess what? The jury will be sitting for hours or perhaps even days while the defense presents its evidence in an offer of proof. Because we're allowed to do that. That's going to happen. But then you're going to have Nick. That's why Baldwin has to be so patient, because at a couple different times I saw towards the end, he was just like, whatever. Because it gets exhausting. It is. Whereas should the Court of Appeals find that the trial court was in error, then the jury will not be forced to wait outside the courtroom or in their hotel rooms for hours or even days while the defense presents its offer of proof. The trial will run more efficiently and at less expense should these issues be resolved by the Court of Appeals before any trial takes place. And now I make my notes, you guys. I'm telling you, Nick is going to go crazy. Yuri's math teacher gifted 10 membership. Woo! Who turned green? Let me know when you turned green. Here come the breadcrumbs. Let's take a look. This is I give you guys my little notes. Don't pay attention to this side yet. I'll go like this, not to disrupt the class here. You guys, number 8, the court's August 28, 2024 order and September 4th order both involve substantial questions of law. Like, who do you think you are, Judge Gall? Like, you know the law, don't you? You know the law. And the early determination of those issues will promote a more orderly disposition of the case, to wit the following. Here we go. Ready? The September 4, 2024 order denies Richard Allen the ability to present a defense. This is violating both state and federal constitutions. What are you doing? Like, this is a fact. This is a fact because you know what? When they supplement it right here and say these things, you guys can say, oh, yeah, you're right. How could this possibly be? Because I'm going to give you an amazing example. And here it is. On September 18th, the defense filed its first Franks. That was the big daddy, the amazing Franks. And Judge Gall, literally said when she was about to boot them, right before she booted them, she's like, and I haven't even read your little novel. And I can't believe that they're not even citing her talking about that type of stuff. That this isn't a novel. This isn't some romance novel. This is them explaining, being so transparent that they've been working on this stuff way back then. So in that first Franks, it was clear. Okay, so the defense here is starting the timeline to show, hey guys, way back at this time, we started on our first Franks notice, at which time the defense revealed in great detail its defense that Odinism/Norse paganism explained the unusual nature of the crime scene and therefore identified particular suspects who were tied to the victims and or tied to the crime scene. 100% they're tied to the victims because of who the kids dated. This was known back then, so think about it. Then the September 18th, 2023 Franks notice was very transparent, and it left no doubt the defense would be claiming that A, Odinism, Norse paganists were involved in the murders of the victims. B, law enforcement began investigating the links between the crime scene and Odinism within 3 days of the murders. Like, you guys did it. You did it. Like, law enforcement. They did it. C, like, I'm taking it from the discovery. You guys chose not to go that path, and you can explain at trial why you didn't. But Richard Allen has a right to explain why at trial that was a huge mistake. Or maybe there's other reasons why. C, that law enforcement began investigating Brad Holder and Patrick Westfall as suspects within 3 days of the murders. They're not throwing out some random ass names. Okay? The defense is going with people that were in the discovery that law enforcement looked into, and then miraculously, oh, wow, we don't have this, we don't have that, we don't have this, we don't have that. We lost things. All right? I think alone because they lost things, then that gives me the right to have this defense. Because you can't prove to me how they were cleared. You can't prove to me how law enforcement cleared them. And so we're going to let the jury decide of the weight of this. When we show this, the jury gets to decide. You don't, Judge Gall. You don't get to decide if this is... She's basically saying, no, the jury's never going to see this. Okay, why? Because it's going to confuse the jury? What? Talking about the investigation is going to confuse the damn jury? Then I'm sorry, then those idiots have no business being on the jury. If us talking about the investigation of what law enforcement did during their years of investigating this case is going to literally confuse the jury, why are you guys planning on speaking in Spanish? How is that going to confuse anybody? How did you get to Richard Allen? How did you get to Brian Kohlberger? How did you get to where you got, motherfucker? Think about how crazy this is. We're not allowed to talk about your investigation? Are you out of your fucking mind? How is nobody talking about this? You want to talk about sensationalism? That's the goddamn mainstream media is sensationalism. Mainstream media. This is what y'all need to be talking about. I want so badly someone from mainstream media to get arrested. And then maybe they'll wonder for the first time in their lives how important it is to actually cover stuff like this. This is just absurd. So, hey, guess what? Law enforcement began investigating Brett Holder plus Westfall as early as 3 days. A, no, who cares? D, that at least 3 law enforcement officers continued to investigate into the Odinism ties to the murders, and particularly ties between Brad Holder, Patrick Westfall, and certain men in Rushville, Indiana. Oh, so then they did it. So then they're continuing, right? E, that Richard Allen had no connection to Odinism. And so that's why and then there's some really huge ass weight there. If I'm on the jury and I get to see this, okay, and then you guys show me that Richard Allen has no ties to any of those people, has never wanted to be in Odinite, never wanted, he just doesn't know these people. There's no ties. He would have no reason to leave the crime scene like that. He wouldn't know how to. As a juror, I'm like, let me decide what I think that crime scene looks like. And it's like the Karen Reed case. They had no idea about the federal investigation. And did you hear them talking in that deliberating room because of that? Because that was kept out? That's what confused the damn jury, leaving pertinent shit that should have been in out. You have law officials and law enforcement in this case that came out and said in depositions that more than one person is responsible for this. And we can't talk about that? Like, get the fuck out of here. Oh, shit. No, sorry. Not today. Now. Getting juicier here. In spite of the prosecutor knowing that the defendant, Richard Allen's third-party defense on September 18th, like they knew this way back then, right? The prosecutor waited over 7 months before filing its motion in limine on April 29th, 2024. At the time, remember, that's when the trial was set for May 14th. The prosecutor's motion was filed 15 days before when that trial was supposed to start in May. But they've known since this, on April 29th, the prosecution filed its motion in limine requesting in paragraphs 7A and 7B the following. And this is just disgusting. 7A and 7B that the court prevented or is trying to prevent the defense from presenting evidence that explains the defense's belief of what the crime scene shows. Wait, say that again? Yeah, exactly. So in paragraphs 7A and 7B, when the defense put in their motion to suppress, it was basically ultimately asking the courts to do the following. You're going to, the prosecution's asking the courts to say, we want you to prevent the defense from presenting evidence that explains the defense's belief of what the crime scene shows, i.e., that certain signatures the killer left at the crime scene revealed that a ritualistic killing occurred at the hand of Norris paganists. Now, think about this. What if I wanted to suppress that, you know how killers take things and they take trophies? I want to suppress these trophies that you found at, let's say, my friend's house, but you can't, they're at my friend's house, they're not at mine. So how are you going to sit here and say that they're mine, though? I want to suppress that. So instead of somebody that's a killer taking a trophy, they basically left a trophy, which was the crime scene, the way that it was staged. And so you want that suppressed for us to be able to tell you, the courts, the jury, you want to be able for us to not be able to tell the jury and have a expert witness who testified August 1st, 2024, who does mostly work for the prosecution, FBI, trained them. You want us to be able to not talk about what that crime scene looks like. Like, that's like not allowing the ARCA guys to testify to the crime scene of that's John O'Keefe. Is this even possible? Da da da. What? So you're trying to prevent us from not being able to have an expert witness who we had. So, because that crime scene, our expert is going to say the following, and because Richard Allen has no ties to the Norse paganism nor Odinism, the evidence the state of Indiana sought to exclude would prevent Richard Allen from arguing that Richard Allen did not commit the murders, as he knows nothing about Norse paganism and therefore would have no motive. But more importantly, that's why I highlighted this part here, no knowledge to be able to leave the signatures. Okay, leave out the word motive. He doesn't know how to do. He wouldn't know how to do that. Okay. Again, you suppressing this versus this is about, is it admissible? Is it not admissible? This is admissible. And then let the jury decide how much weight to apply it. But how do you think that you can say that this isn't admissible, that we're not allowed to talk about the damn crime scene through an expert testimony? That's unfucking heard of. Unbelievable. That's like, you have a phone expert and I have a phone expert, but you can't use your phone expert, but I get to use my phone expert. What? No, no, you don't. No. On August 1st, 2024, the defense presented evidence through expert testimony, Dawn Perlmutter, that the crime scene was a textbook ritualistic killing. This opinion was offered from an expert who literally wrote the book on analyzing a crime scene for ritualistic murder and also has taught FBI and other law enforcement agencies all over the country what a ritualistic crime scene looks like. You've got to be kidding me. That's who testified on August 1st. Wait, Lana, you're saying that? Yeah, I'm saying that this person who taught the FBI, who taught law enforcement about ritualistic killings, what they look like, what to look for, that's who testified for Richard Allen on August 1st? Mm-hmm. Furthermore, Dr. Perlmutter has almost exclusively worked for law enforcement and prosecution, not the defense. You know what's crazy with that? Isn't that kind of remind you of like Cyray? That reminds me of Cyray. That reminds me of Cyray saying, like, I normally just work, I do a lot of work for the prosecution. He's not one to get on there, you know. He was law enforcement. So here you got a woman that, so they kind of did that in the Delphi case. They went out and got an expert for the crime scene. And then this person would be backing the fact, and this lends credence to why the defense wants to talk about it. How can this judge, after hearing that testimony in that courtroom on August 1st, do what she did? The jury would be able to assess the weight to give Dr. Perlmutter's assessment of the crime scene. That's what I've been saying this whole time during this whole live, is about admissibility versus the weight. This shit is admissible. You cannot take this out. You are violating Alan's rights. You're violating our rights when you do this. It's in, and then you let the jury decide on what they want to apply to the weight of the evidence when they're going to be in deliberating fashion in that room. Because if you got to hear all of this as a juror, you're going to just ask yourself, I don't believe that one person did this, and this crime scene, this, when all these things together, this is what would give you the reasonable doubt without a doubt. Not being able to talk about the crime scene. Are you kidding me? Furthermore, in its April 29, 2024 motion in limine, paragraphs 7E, C, D, E, F, G, and H, the prosecution requested the courts to prevent the defense from presenting evidence that tied alternate suspects involved in Norris paganism to the murders, including evidence of the investigative efforts. Again, you want us not to talk about your investigation. That's how you poke holes at a case for reasonable doubt. But we can't talk about, so they want us to, again, not talk about any of this. And this is including the evidence, of the investigative efforts of 3 law enforcement officers who believed that the evidence credibly pointed the finger at certain third-party suspects. You want us to not show the world what law enforcement personnel uncovered during the investigation into the murder of who killed Libby and Abby. These officers, 3 of them, one of which I heard testify, Todd Click, smooth as butter. They're saying that there's third-party suspects and that the social media of one of those third-party suspects, who we all know now, Brad Holder, that provides a nexus. There's your nexus. Gall's like, there, you got to provide this nexus. I even think that just the Abby dating his son is a nexus to me. I don't care. But whatever. A nexus between third-party suspects and the murders. So then there's like, well, you have to connect it to the murders. Well, okay. So we're going to use his Facebook post that is identical to the crime scene. That's our nexus, is his social media Facebook post. You guys, what's blowing my mind is that they've known about this for a year. It's September, what right now? 11th. They've known that this is the defense's theory. They've known this since September 18th of 2023. Waiting to the last minute to file this stuff. And then here's Judge Gall doing everything. Yep. Keep out. This is why they don't want cameras in that courtroom. I don't know how in the world there is no cameras in this courtroom. The U.S. citizens have an interest in corruption. Where's mainstream media filing shit that's saying that her decision, we trump it. There is definitely a public interest in this case if this will show that government officials were covering up for. That's corruption. Corruption. We have an interest in corruption. Richard Allen wants us to be public. Richard Allen wants us to be on TV. And Judge Gall, no cameras. Fuck you. Why? Why do you think no cameras? It's disgusting. Here's where we get turned up. You guys, number 13. Furthermore, in its April 29, 2024 motion limine, paragraph 7I and 7J, the prosecution requested that the court prevent the defense from presenting evidence that third-party suspects, Keegan Klein, who that's all you want to know is Anthony Schatz, and Tony, his dad. They want to keep out this Keegan Klein and Tony Klein committing the murders, even though credible evidence existed. Now, I think it's interesting when they use the word existed, because does it not exist anymore? There is credible evidence, even though credible evidence existed, that A, Keegan Klein had arranged to meet one of the victims on the day of the murders. Wait, excuse me? So that is true? There is credible evidence. When we say existed, was it destroyed? You guys get where I'm going with this? Think about that. Was this a typo? How could the evidence... I would be saying, wouldn't you say, like, even though credible evidence exists, that A, Keegan Klein had arranged to meet one of the victims on the day of the murders? Ready for this? B, Keegan Klein implicated his father, Tony Klein, as being involved in the murders? You're going to allow 60 confessions, allegedly, of Richard Allen when he's being, in the conditions he was, and none of them are the same. But we can't talk about how you guys were trying so hard to pin this on that group back in the day. So much so that, wait till you hear this. So Keegan Klein, there was evidence that they were setting up a meeting to meet to meet one of the victims. And then B, Keegan Klein implicated his father as being involved in the murders. And then C, law enforcement tried to tie Richard Allen. When did this happen? Law enforcement tried to tie Richard Allen to Tony Klein and arguably only interrogated Richard Allen because of law enforcement's initial belief that Tony Klein and Richard Allen knew each other and committed the crimes together. Do you understand that this is new reveal here? Because I thought the reason that they interviewed Richard Allen was because let's go back to the beginning and let's see. Oh, wait, here, Richard Allen talked to one of law enforcement people that next day to say, oh yeah, I was at the bridge. And so they happen to come across those notes. I don't believe that that's what's going on anymore. You guys, look at this. Law enforcement tried to tie Richard Allen to Tony Klein. When? Now I want to talk about some timeline. When? What's the date? When? When did this happen? Law enforcement tried to tie Richard Allen to Tony. When? Was it a year ago? I mean, 10 years ago? Not 10, but 4 years ago? 5? 3? When did law enforcement try to tie Richard Allen to Tony Klein? And arguably only interrogated Richard Allen because of law enforcement's initial belief. When did they initially believe this? Because I thought that they didn't even know that Richard Allen existed because that interview fell through the cracks. This is painting a completely different picture of why they want to suppress this. And it has to do with the investigation, you guys. If they had phone records of Keegan Klein, if they had phone records of Tony, right? All back then, they're trying to zero in on these guys. Everybody's watching them. They're going through their call history. They're seeing who they're calling. They're seeing who they're talking to. Richard Allen's on none of that, right? So I want to know when they thought, oh, here's this guy that says he was in the park. Okay, let's try to tie him to Tony. What? Yeah. Once you've come across that in your investigation, what do you mean? You don't need to try anything. You're investigating and things, just let it talk to you. Let the evidence, like, read it. Read the phone records. See what they say. Follow the evidence. Follow the motherfucking evidence. Stupid fucks. Shit pisses me off. So we're not allowed to talk about this? Even though this is your investigation, but we're not allowed to talk about this. And arguably only interrogated Richard. Interrogated. So when did they interrogate Richard Allen? Remember, that was in October before they arrested him. Because of law enforcement's initial belief that Tony Klein and Richard Allen knew each other and committed the crimes together. Oh my God, we can't talk about that. And then somebody then made a decision just to say, okay, let's dump it on this guy. All right, we can place him there. Da 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 da. Unbelievable. The law enforcement officials discovered, that's that child porn. Ooh. Keegan Klein's personal cell phone during the course of their investigation, but we can't talk about that. And law enforcement officials actually transported Keegan Klein to an area near the crime scene to corroborate his version of what this is when they were down the Washbaugh River, of what his father, Tony, did near the crime scene on the day in question. 14 is furthermore in its April 29, 2024 motion in limine, paragraph 7K, the prosecution requested the court to prevent the defense from presenting evidence of third-party suspect Ron Logan. We can't talk about Ron Logan. Are you out of your mind? Ron Logan. We can't talk about the evidence of third-party suspect Ron Logan, even though there is credible evidence existed that the bodies were found on his property. We can't talk about that though. Where were the bodies found? Oh, just on this area over here. B, an FBI authored probable cause affidavit stated that Ron Logan placed a phone call on or around his property around 2:09 p.m. using cell tower data. Oh, wait. What? 2:09? Wait. You guys remember that live I just did with Teresa? And we were talking about what was going on? 2:09? Interesting. That's right before the bridge guy video at 2:13. Yep, prosecution expert testified that BG video originated from the area of the high school. That is correct. Okay, check this out, guys. Ready? This is the FBI did this probable cause. Okay, and hey, guess what? An FBI authored probable cause affidavit stated that Ron Logan placed a phone call on or around his property 2:09 p.m. using cell tower data. Ron Logan provided false information about his activities during the times the crimes were committed and employed others to assist in deceiving law enforcement, and furthermore plotted an alibi for a crime that had not yet been discovered. But we can't use this. And all of this happened, and the nexus is the girls were found on his property. That's your nexus? That's your nexus? Are you kidding me? Like, who could possibly read this that's gonna take it on appeal, because they will, and say to themselves, oh yeah, all of this should have been suppressed? Nobody. Absolutely nobody. Not a single person. Okay? Not a single one. But hey, guess what? all of this stuff right here. Oh, wait, we can't forget this. By the way, a court found that said probable cause affidavit provided probable cause that evidence of the murders would be found on Logan's property. We can't talk about that. How did you obtain your search warrants? Because you all said that a court found that said probable cause affidavit provided probable cause that evidence of the murders would be found on Logan's property. That's how you obtained those search warrants, right? But are we just going to talk about how law enforcement just lies to get them search warrants? The FBI, whoo-wee. But none of this. This is out? This is out? This has nothing to do with oh, that's right. It provides so much reasonable doubt, doesn't it? If a jury hears this, there's no way they're convicting. It's got to be suppressed. And it's suppressed right now. Furthermore, 15, in its April 29, 2024 motion, lemony, paragraph 8, the prosecution requested that the court prevent the defense from presenting evidence from law enforcement. Again, evidence from law enforcement. This this isn't our made up evidence. This is what y'all did. You guys did this. And when I say you, law enforcement, prosecutors, criminal justice department, okay? All of you people that are in the agencies of policing this great country. It's your evidence that we're now not allowed to use. So the prosecution requested the court to prevent the defense from presenting evidence from law enforcement officer Todd Click. Oh my God, we can't use Todd Click. How? He is who investigated the Norris Pagan Odinist ties to the murders, as well as the ties of certain third-party suspects to the crimes, primarily those identified in paragraph 7A through H. Now, how about this, guys? You know, let's say that I'm part of a biker gang, all right? And we're all on our motorcycles, right? And but part of the biker gang is that, yeah, we like to drive around on our bikes, whatever, blah, blah. But we also do and sell drugs, right? So I could commit a crime with other people that I'm in a biker gang with, right? And I didn't use my motorcycle that's part of my biker gang, like, woo, and my vest and all that. I didn't use my bike to commit the crime, right? But with my biker gang people, I used other things to commit a crime because we were pushing a bunch of drugs and we were using these kids and nope. The girls weren't run over, so you can't go with the whole biker gang. There's no signs that these girls were killed by biker gangs because they weren't killed by motorcycles. That's how I feel that what they're trying to say. Like, what? I could be part of something and with those people that are my friends commit crimes that have nothing to do with my bike. I don't understand. This is just wild to me. But what if there were bike tire tracks, just one single line tire tracks around there? Oh man, that would tie some motorcycles to it. Yeah, but it could be something else, or you could just have somebody come testify and say, well, no, that's not it. It could be a fucking four-wheeler. It could be this, it could be that, it could be. Well, we'll let the jury decide that. But if there was like tire marks and there was only single ones, so it's not a car, it's got to be a bike. Oh, can we tie it to the bikers then? Well, I wouldn't see why not. How could you suppress that? How could you suppress that? How could you suppress if there was tire marks at a crime scene and they were consistent with being tire marks from motorcycles? Well, that doesn't mean that a motorcycle gang did it. Why doesn't it? Why can't it? I think that it could. But because I want to say that, no, you're not allowed to. Why can't I say that? Let's say there were biker tire marks there. I can't say that the biker gang was the one that did this because there's evidence at the crime scene of tire tracks belonging to motorcycles. I would think that that's pretty solid, right? If that's going to be my theory and that's what's tying them to the crime scene, how can this judge say that, no, you're not allowed to talk about that? That's going to confuse the jury. How? This is the crime scene. If I have an expert come in to testify that these tire marks are consistent with Harley Davidson whatever, I can't do that. That's what this is basically saying, by the way, that I just can't. Nope, that's going to confuse the jury. Okay, sounds good. I can't talk about Ron Longren and her property because that's going to confuse the jury. No, it's not. How do you not have to explain any of this why you can't use this? There was no explanation as to how any of this is out. And this is all coming from law enforcement. This is all coming from the discovery. I can't use the criminal discovery to defend my client? I can't use the criminal discovery to defend myself? How is this legal? Oh, guess what, guys? It's not. It's not legal. Okay, this is not legal. This is a violation of Richard Allen's and all of our rights. What Judge Gall just attempted to try to do a couple weeks ago is a violation of our rights. Some people say, how is this legal? Guess what, guys? It's not legal. It's not legal. And if there's anybody, like I see Karen Reed has all these supporters. I see Karen Reed has all these people like, free Karen Reed, free Karen Reed. How about free ourselves here for a second? We need to be down in Carroll County, okay, with megaphones. We need to be advocating for our rights, which are to Richard Allen's rights. And if you don't advocate for people's rights, you can't say, well, he's just so guilty. Fuck the guilty or the innocence. I don't care if Richard Allen is guilty or innocent. That's not what this is about. Okay? This is about you can't do this. You can't do this. So we need a rolling rally for this case. I'll set it up. I will drive to it'll take me 3 hours to get there. Who's going to come with me? I will be up on. I have my megaphone right here. Let me grab it. So I stop being on a team here. Can you just be on the team of our rights? I'm coming for you. Get your ass over here. You guys, this is crazy. I don't want to give feedback if I was to use it. I think it'll feedback your stuff. I don't want to do it, but this puppy can get loud. So this is not about innocence or guilt. This is about suppressing our rights. You're trying to suppress our constitutional rights. You're trying to suppress everything that the United States of America is built on. Can a higher court address this after the ruling? They could address it at an appeal. That's the beginning part. But Indiana, shame on you. Shame on you. But there's a there's a gag order. So it's not like But I think why can't and I know they're not going to try to do anything because they don't want to get tapped, but it would literally take 20 minutes for someone to read this document and see that our rights are being violated. It's crazy. It's crazy. I want to know if Richard Allen had tits and blonde hair and blue eyes, if people would be covering it differently. And the answer is yes. The answer is 100% yes. And that's when you know this country has biases. And mainstream media is the motherfucking biased motherfuckers. If Richard Allen, that's going to be my sign. If Richard Allen had blonde hair, blue eyes, and a pair of tits, everybody would be on those stairs. That's the truth. That's going to be my sign. Fight me. And I'm going to have a sign that says, fight me. Fight me. Absolutely, Lana. The document reads like a lame excuse to violate rights. Yes. Tell me I'm wrong. If Richard Allen had tits, blonde hair, blue eyes, what would be going on? I can tell you that everybody would be down there. Mainstream media would be covering it. But he looks like a caveman right now. It's kind of like Stephen Avery. Oh, please debate Rick Snay. Does Rick Snay think he's innocent or guilty? Because I don't want to debate innocence or guilt. I want to debate. Look at this. This is a violation of our rights. We're just going to stand by here and not say anything about it. Welcome, members. Skeptical Curiosity. Woo! I mean, this is what drive people to get drunk reading this shit. Everybody that's a damn lawyer worth a goddamn should see this shit, call up Baldwin and Rossi and be like, hey, do this here. We want to give you some advice. You can do this. You can do this. Everybody should just be pouring their knowledge into helping these two lawyers because this is absolutely absurd. Now, I wanted to look into what was said for at this hearing when that Dawn woman expert for for crime scenes. Listen to this. On page 2, Dr. Perlmutter, it says that you are a subject matter expert in the area of expertise, and it lists symbols, symbolic, anthropology, all this crap, right? And so she gives all her credentials, right? So she says, moving forward on page 3, they're going through her CV. Then we get to, I train local, state, and federal law enforcement agents, analysts across every branch of government. That's who's testifying to this crime scene. And okay, great. Again, Homeland Security, sometimes DEA, just FBI, different agencies. Now, the next one is ritualistic crime scene investigation. What's the difference between ritualistic homicide and ritualistic crime scene? Those two courses. The ritualistic crime scene investigation is everything except the homicides. Like that can be theft of human remains. It can be blood ritualistic or rituals that are done with certain subcultures, mutilations, just every different type of manifestation of, it can be narco cults. And she's just saying a bunch of crap. Okay. That don't involve homicides. Yes. Okay. That's an advanced class that is for intelligence analysts and investigators, which is called the symbolic analysis methodologies. What's that class about? And so she goes on to explain that, but that's an advanced class. Okay. And we'll talk about methodology later, but let's go into this part. The last one that you have there, racially motivated violent extremists. What's that? Oh, that's the training answer. That's the training I've been doing for the past couple of years. Racially motivated violent extremists involves like white supremacy groups. And when I do these trainings, I focus on the identifiers, all the different types of ideologies and religions that they hold, and like things that tattoos and rituals and initiation rites that would be associated with those groups. Okay. So they have to lay all the foundation to say, okay, now you're going to testify to this. Baldwin says, are you an Odin expert? Would you say? I'm not. I wouldn't say I'm an Odin expert. I would say I'm a generalist in the symbols of all of these different groups. So I'm able to distinguish from somebody practicing Odinism versus Christianity. So she's explaining that. Okay, would it help if you had some water? Oh, wrong part. Not that. So I wanted to know about what this woman had to say. And so we keep going. And okay, if you show up at a crime scene, I think it would be natural, what is this guy trying to say? What would he say? What do these symbols mean? Well, it's very important in figuring out who did it, her answer is. And the biggest distinction between sort of behavioral analysis, like the BAU, and the anthropological approach is with behavioral analysis, they're thinking about rationale. Like me, I'm a rational person. It's a rational Western perspective where most of the people doing these in these different ideologies and religions, they think magically. Wow. Fucking wizards, Harry Potter's over here. So magical thinking is a huge part of interpreting what is going on because they're not thinking about it logistically. They're not thinking about it logically. So if they leave items there, it's not because they're leaving it. They accidentally left it. Everything has meaning. Everything at the scene has meaning. They're either doing it as an offering or to gain power, achieve certain things. That is the significant difference. From a rational, again, it's very hard to apply rational Western thinking to why somebody would do certain things. And so this woman is testifying in front of Judge about this crime scene and how it is textbook. It is textbook. And I wanted to get to that part where she talks about direct examination, direct. All right, 4 forensic indicators that have murder weapon. Okay, what we see indicator. Okay, question. Number 4, forensic indicator you have is the murder weapon. What? Why is that indicator of ritual murder crime scene? Well, because of the weapon of choice is usually a knife. It's very rare found at the scene. It's never going to be there, basically. It's something that would be an object that would be very important to the offender, and that's what makes it part of the ritual. It's a ceremonial object, so you're not going to be leaving that. Okay. So she goes through all of the stuff. Lastly, talks about blood. Then during this, they offer Exhibit FF. And so this is a crime scene photo. What about this crime scene photo causes you to believe that it applies to number 1, place of death that determines its ritualistic murder? Her answer, this is crazy. The aerial view really shows in a lot of these cases that it's almost like a clearing. And in this case, it's surrounded by trees. And during these rituals, they have to separate designated sacred space from profane secular space. That's so they need a clearing to where they do it. And being near a body of water is very, very common. I put the circle question. The question is, it's significant to you that where the circle is, that there's a space there. Oh, I put that circle in because it's typically referred to as a casting the circle. And even neo-pagans, when they do it, there's a space for the ritual. It might not be a perfect circle, but the fact that it was a clearing and they're not at near relatively close to the water. Well, number 2 is the date of the death. Does the date correspond to a holiday? What does your research reveal? Well, the only holidays that fall between February 13th and 14th is one, and there weren't any events or anything at that time. It's called whatever that is. It's an Odin holiday for the son of Odin Valley. And it actually is a sacrificial holiday. Are you fucking kidding me? Wait a second. Wait, between February 13th and February 14th is one, and there weren't any other type of events. So right here, it's called Valley's Blot, and it's an Odin holiday for the son of Odin Valley, and it's actually a sacrificial holiday. The thing with Nordic holidays is they're from sundown to sundown. So even though it's on the 14th, it starts on the 13th with sundown. She isn't an expert on ritual killing, so, huh? This is unbelievable. This is the woman that's teaching the FBI. This is the woman that's teaching the FBI. She's like, well, the dates they're not as strong as indicators. It's just another thing to look at. Like, you just look at everything. It's a specific Odinist holiday. There's other dates like this and that. There's other things, blah, blah, blah. Oh. So what is a strong indicator, at least in this case? It's one indicator, yes. All right, the next question, or the next is the cause of death. Sharp force injuries to the neck. Sharp force injuries to the neck. Do you have, let's talk, tell why the cause of death in this case is an indicator, forensic indicator, that this was a ritualistic murder scene. Ready? Because with sacrificial, and there's different types of, like I said before, there are different types of ritualistic murders. So they're done for different reasons. So for example, this exorcism that can be done with fire, people, I had a case where a little girl was burned to death in an exorcism. What? You have other cases where the bodies are dismembered for different reasons, but the specific slitting of the throat is indicative of a sacrificial offering or initiation type. That is, again, throughout history and across cultures, that's how sacrifice is done. It's by cutting the throat and getting the blood to come out. Mr. Baldwin says, okay, I'm going to move to admit just the autopsy reports as evidence of what happened to these girls. Question, and did you review the autopsy? I don't remember. I reviewed the reports and the photos, yes. Okay. Move to admit. Any objection? No. Okay. So then they go on and on, right? I talk about the murder weapon. Then Exhibit JJ is we're going to be talking about. But I really want to focus at this time on the middle photo, please. We're talking about symbols in the crime scene. What is indicative of it as it relates to that picture right there? The branches were placed, very carefully placed in that arrangement. It appears to be identical to the making, and the person is creating some type of symbol. In this case, after reviewing everything in the context, it appears to be what's called a bind rune. What is a bind rune? A bind rune is when you combine two or more runes and to create personal symbols or to combine the power of the two different things. It's done quite often, and it's a very common type of practice, which, magical practice. Now, let me explain something. So this woman testifies to all the stuff. She read the autopsies. Here's the crime scene photos. This is what I do for a living. And this is textbook a ritualistic killing. Or could it be textbook a copycat? Or could it be somebody that's trying to make it seem like it's like that to push law enforcement in a different direction? Okay. But at the end of the day, don't you think the jury should hear this? I do. I think the jury should hear it. I think Richard Allen has the right for the jury to hear it. And then the jury can decide yes or no. Because you could also argue the fact that somebody did this to make something seem like it was that. Absolutely. Great point there, Yuri's math teacher. I found all the eyewitness accounts to be pretty damn confusing. I think the freaking sketches are confusing. I think the order that you release the sketches are very, very confusing. So who are you to tell me that we can't use this? All right, next up. All right. Furthermore, remember Todd Click? I heard him testify, and Click's testimony would provide evidence that connects those third-party suspects to the crimes, as would the testimony of law enforcement Kevin Murphy, who also investigated said connections alongside Click, including testimony that Elvis Fields posed the question to him of if Elvis's spit would be found on one of the girls, but he could explain it. You guys, law enforcement. So let me get this straight. We're supposed to trust law enforcement. They're supposed to be able to testify. Here, the defense wants law enforcement to testify, but here the prosecutors are trying to prevent these law enforcement people from testifying. When have you ever seen such fuckerage? How about this? Why is it so split? And I think that's a good thing. I think it just shows that people have their own fucking brains. But there was people that clearly could not get behind the fact that, wait a second, Richard Allen is who you arrested for this? What is going on? You don't just get to say that something doesn't come into court because it's a difference of an opinion. This is just, to me, I can't even. This is so sick. This is so sick. But you have a guy that told law enforcement that if he found his spit on the girls, he can explain it. Furthermore, Murphy would be able to tie Elvis Fields from Rushville, Indiana, to Brad Holder of Logansport, Indiana, and that Brad Holder was an active Odinist whose son Logan Holder dated one of the victims, and who also has changed his story multiple times about whether he had ever met the victim, and whose social media posts include evidence that tied Holder to the crime scene. Furthermore, in its April 29, 2024 motion in limine, paragraph 9, the prosecution requested that the court prevent the defense from presenting evidence of geofencing. Now, this is interesting. Cyrus did an episode of this morning. Geofencing. Is it unconstitutional? Even though that geofencing evidence provided evidence that other third-party suspects were in the area of the crime scene at the time the prosecution is claiming that the crimes were committed. Say that again? You heard it right. This is unreal, man. This is all in the discovery, but we can't use it. Even though geofencing evidence provided evidence that other third-party suspects were in the area during the time of the crime. Number 17, after the May 13, 2024 trial date was continued, the court held the hearing for said motion in limine on August 1st, 2024. And likely because of the voluminous amount of evidence it received and reviewed, the court was unable to rule on the state's motion limine until September 4th, 2024, which was 40 days before the scheduled October 14th trial date. 40 days to then say, hey, guess what? You can't use any of this stuff. Included in the court's ruling was the court's belief that the admission of the evidence would confuse the jury. Unfucking believable. The defense respectfully rejects that evidence that the court excluded from the jury would actually provide the jury an understanding and an explanation of why the crime scene appeared the way it appeared. In fact, the defense would argue that by keeping the evidence of Nora's paganism from the jury, the jury would be confused as to why the crime scene appeared the way that it appeared. Was that my goal? You guys, this is unbelievable. Guess what, guys? The jury is going to be confused if we talk about the crime scene. Stop! Stop! You can't make up the stupidity. Hey, guys, guess what? If we talk about the crime scene, no, actually, it wouldn't, because then maybe I would understand why it's so fucking disgusting, all of this shit, and that, oh my God, yeah, this is some freak fucking show. This is some ritualistic bullshit. This is some, this makes more sense. This was done by multiple people, not one man. I can wrap my head around that then. Okay. I can't wrap my head around how this could possibly be done by one guy, two girls, in an area, nobody heard screamings, and I'm in and out, right? And they're all searching right away, and nobody finds this crime scene. Nobody finds the girls. The crime scene, talk to me. I'm just getting stupid over here. Next up, what do we got here? Evidence that the court excluded from the jury would actually provide the jury an understanding. Oh my God, imagine that. And see right here. Additionally, this is what I've been saying. Let the jury decide. That's what we have the right to do. We have the right for the jury to decide our fate, right? Based on the evidence presented, and then they can apply the weight, but you just don't get to play judge and jury. You don't. And additionally, right here, the inclusion of evidence of third-party suspects as being connected to the murders is not confusing, but rather easy to understand, and that it is up to the jury to either accept or reject the defense's contentions that the evidence connects Nora's paganism and third-party suspects to the crime. Again, who the F do you think you are? Done by one man who doesn't match the DNA, go figure. Exactly. And then how am I supposed to tell? So what do I consider the jury? Guess what? You're going to hear about DNA that's at that crime scene. And that DNA does not match my client. Oh. But we can explain that. We can explain why. Because our client didn't do it. And we're going to explain through cross-examination that they didn't what? I have to use just cross-examination to poke holes at whoever they decide to put on the stand. So I can't even say, wait for us. Wait for us when it's our turn to show you guys what the state has been trying to bury for the past 7 years. Unbelievable. Unfucking believable. Start blaming the law enforcement people. Essentially, with its September 4, 2024 order, therefore 40 days before the trial is scheduled to begin, Richard Allen's defense was completely gutted. Completely gutted. Exactly. And they knew this. Do you want to know what the word fair is? I said this the other night. You don't get to start a game with my life up 21-0. Okay? That's not how this is going to play out. If anything, I get to start up 21-0 because I'm presumed innocent, motherfucker. You have to prove that I'm guilty. That's how I would do my opening. Richard Allen is owed the right for all of you guys right now. He is innocent. He is innocent. They have to do this, 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 and this, and they can't. And if they can't do all of those things, then you must acquit Richard Allen. That is the law. That is what reasonable doubt is. And you know what would make it easier for these people to be able to say that is, oh, give me other possibilities. Give me other possibilities. That's what creates reasonable doubt. Right? If other things are possible, then fuck yeah, there's reasonable doubt. But I'm not allowed to talk about those possibilities. No, Judge Gall, that's not how this works. No, no, and no. I don't get to talk about their shitty ass investigation. I don't get to talk about how shit they are. They couldn't even keep damn files straight. They couldn't even not record over interviews in a double homicide. I can't talk about all these other suspects before they got to, okay, Richard Allen. Fuck out of here. Nothing tied Richard Allen to any of this shit. Richard Allen just in the middle of the day decided, you know what? I'm going to just fucking go kill. I'm out here and next kid I see, I'm just snatching him up. Meanwhile, Richard Allen didn't know the kids were going to be out there that day. But let's talk about who did know. Let's talk about this real timeline of when they say the crime happened, but yet the phone comes on at 4:30. Get the fuck out of here. Richard Allen has the right to have his defense. You know how long it takes to prepare for a trial and how you're going to, what order you're going to ask, your witnesses to come forward, and then you're going to question them and what you're going to question and how you're going to make all of that flow. Because guys, the tool of cross-examination is you have no idea what someone's going to say on the stand. Okay. You might have a pretty decent idea if you've deposed them, if they've testified before in connection with that case. But when someone's going to get up on the stand and they just start saying shit that's not even true, how do you combat that? How do you impeach that? Well, you better know your case inside and out. That's how you impeach it. How do you cross-examine somebody when they say off-the-wall shit, right? And the state's leading them to say off-the-wall shit. And then if you don't know the case, you're going to get your ass handed to you because they're going to get away with that lie. Because I can't cross-examine it properly because I don't know the case good enough. I don't know what they said in that interview. I don't even have that interview because it's missing. Horrible. This case shouldn't be going to trial. If Alec Baldwin, if his case could have got dismissed for that fuckerage, this case should be dismissed 30 times over for fuckerage. Unbelievable. Unbelievable. Like I said, if Richard Allen had tits, blonde hair, blue eyes, this is not seeing the light of day. Much love to all who care about justice. Bunny Murphy, 4 months, shake it. All right. Let's finish the end here. Again, right here, you just gutted our defense. Certainly, between the Franks notices that have been filed and were made part of the record and the exhibits that were attached to those filings, as well as the evidence and testimony this court received during the July 30th to August 1st, 2024 hearings, the Court of Appeals would have more than enough record to review to either support or negate this court's September 4th, 2024 order, as well as the August 28th, 2024 order. The issues to be presented to the Court of Appeals for interlocutory appeal concerning paragraph 7, 8, and 9 of the State of Indiana's April 29, 2024 motion in limine would all involve whether the trial court was correct in granting the state's motion, thereby denying the defense the ability to present evidence. A, concerning its interpretation of the crime scene and how said interpretation excludes Richard Allen as a suspect. B, concerning whether a nexus exists between certain third-party suspects and the crime scene. And C, whether the evidence presented warranted the court from excluding geofencing evidence. The August 28, 2024 order denying defendant Allen's request to suppress incriminating statements violates Allen's state and federal constitutional rights. Those are our rights too. They are violating our rights too. Do you understand that? On November 3rd, 2022, Judge Benjamin Diener issued a safekeeping order which resulted in defendant Allen's immediate transfer to a maximum security confinement facility where he was detained in solitary confinement for a period of nearly 13 months. Defendant Allen was not afforded a due process hearing regarding his detention until June of 2023, nearly 8 months after he was locked away in solitary confinement. Throughout the course of defendant Allen's detention, the state of Indiana began offering up discovery in the form of incriminating statements made by defendant Allen to prison guards, inmate companions, the warden, defendant Allen's treating psychologist, and defendant Allen's family members. Like, none of this happened until after this happened. He didn't, it's not like he made a confession when he was, being interrogated by the police when they brought him in, to talk to him. Defendant Allen then moved to suppress the admissibility of said statements on the basis that said statements were involuntary, thus obtained in violation of defendant Allen's 5th, 6th, and 14th Amendment rights under the U.S. Constitution. Defendant Allen also asserted that his rights under the Indiana Constitution were also being violated. So after you held him and did all these things as he started this process of doing what, these alleged confessions, after all of this, a lot of people would tell you whatever the fuck they want to get out of those conditions. On August 28, 2024, this honorable court issued the amended order or judgment of the court denying defendant Allen's request for suppression and holding in totality that the statements given by the defendant to the various individuals were not coerced. That is absolutely fucking crazy to me. Now, they were just voluntary. I just said, hey, come here. Yo, Wardy, get over here. Come on down here, Wardy. I just want to tell you, I fucking killed Abby and Libby. I can tell you everything about it. I can tell you everything about the crime scene. I can tell you where the knife is. Okay? Where's the knife? Where's the knife? Where's the murder weapon? You want it to be a confession, motherfucker? Where's that murder weapon, baby? Give me that murder weapon. Give me that. Come on, give me the murder weapon. Where'd you put the murder weapon? Where's the murder weapon? Don't you think he would know where the murder weapon is? Where is the murder weapon? Put Richard Allen on the stand and ask one question. Where's the murder weapon, Allen? You confessed 61 times. You didn't tell them where the murder weapon was? They don't have the murder weapon? You confessed how many times? Where is the murder weapon? I don't know. I don't even know what I said. There is no murder weapon. There is a murder weapon. I don't have a murder weapon. But where is the murder weapon? Come on. Come on, man. Objection, Your Honor. He is not allowed to tell that. Come on, man. Get out of here. That's just crazy. What else we got here? With regard to August 28, 2024 amendment order, the issue to be addressed or as follows. Was Richard Allen denied his right to due process under both the state and federal constitution when he was detained in solitary confinement without having been afforded a timely hearing on the state's motion for a safekeeping order? 100% yep. Did the effects of defendant Allen's extended solitary confinement render statements made by him to the prison guards, inmate, all these things? Yep. And C, were the statements allegedly given by defendant Allen to his treating psychologist. Privilege pursuant. Don't you think that those would be privileged? I do. Yep, exactly. How about this? Just very simple. Where's the murder weapon? Where's the murder weapon? If Richard Allen confessed 61 times, you're going to sit here and tell me that none of these people asked Richard Allen where the fucking murder weapon was? What did he say? What did he say when you asked that? Nobody said, hey, okay, great. I believe you. I believe you. Here, I'll get them to believe you. And then you can be out of, solitary confinement. Just tell me where the murder weapon is, and then everything will make sense. What'd you do with the murder weapon? I ate it. I ate the murder weapon. Just like I ate my shit. Just like I ate the paper. Out of here. I think that, I hope that, that when whoever the people that are going to be testifying to these, confessions, I hope that Baldwin and Rozzi go the fuck at these people. I would make cross-examination a living motherfucking hell. And I'd embarrass them too. Yep. Be no shame in my game. That's crazy. You never thought to ask them where the murder weapon was? They're just confessing 61 times, and none of you people asked where the murder weapon is. He doesn't tell you where the murder weapon is. You don't find it, right? How many searches did you take, But you believe that fat fuck King Klein to take your asses down to where? The Wabash River to go searching for something in the river? Huh? Unbelievable. This affects all of us, whether we believe it or not. Absolutely. 100%. 100%. And you know what I love is the people that don't believe it. That just shows you how stupid they are. Block them. Block them. If people can't get behind this, they dumb as fuck. And I can't be around dumb. You can take your stupidity the fuck up out of here. You want to know what stupid people are good for? One thing. Sex. Lana. Lana. Yep. Quote it. Make a t-shirt out of it. The normal remedy of a direct appeal is not adequate. The remedy of an appeal is otherwise inadequate for all of the reasons stated herein. There we go, and it's over. Because of the pending trial date, the defense, would further request that the court issue its ruling on its motion as fast as possible. Go Vandals, come on in. We're going to violate you today. Just a little violation here. But that's about it, guys. The state of Indiana has been contacted and objects to the request, but waives the 15 days to respond, as they have indicated that the prosecution will promptly file their objection. So the state of Indiana has been contacted and objects to the request, but waives the 15 days to respond, as they have indicated that the prosecution will promptly file their objection. Based upon the pending trial date, the defense would respectfully request this court to rule on this matter. Jesus. And it believes the prosecution would also benefit from this quick, swift ruling. This motion is not made to unnecessarily delay the trial, but out of a sincere belief that the court's ruling is erroneous, and will result in an unnecessary second trial should Richard Allen be found guilty. And that's 100% correct. This after this ruling, Judge Gall, she basically just literally solidified, stamped, sealed, delivered. There will be a trial too. There will be a trial too if he is found guilty. Okay? If he is found guilty, this ruling just basically stamped it. But I think there's some breadcrumbs here. I really think that people should focus on this part where they're talking about Tony, Keegan, and what the police were trying to do. And I want to know when they were trying to do it, when this was all being done, that we're trying to link Richard Allen to Tony. What do you guys think? Anybody that knows this case, when do you think that was going on? When would this be a thing? And then when they realized that they couldn't link him, now we have to make sure that they can't talk about him. So what do you think? Thank you guys so much. I wanted to keep this around 1 hour, and it went 40 minutes past because this just makes my blood boil. Absolutely ridiculous. All right, guys, that's going to do it, I think, unless you guys can tell me when you think this timeline existed. If anybody out there knows, comment in the comment section of the video or do some deep dive in and send me what you can find. But I'm truly, truly interested in this. Thank you, moderators. Thank you so much. I'll be on another rant tonight, and I'm going to combine 2 stories together. We're going to talk about the Georgia shooter, what's going on in the Maltwa missing person / husband's accused of, committing murder, but nothing's really moving over there in that department. And then how is this Kentucky shooter still is he arrested yet? I mean, come on. Woo! I'll get back to you, JC, the Music Man. Yeah, get back to me. Is there anything else that you need me to talk about? Anybody? What else? Oh, don't worry, guys. Kevin Clapp's coming. Everything to do with that's coming. Everything. Oh, and I don't know if I've said it publicly for the first time, but I am looking into the suicide of Patrick Rogers, John O'Keefe's partner. People like to stage suicides over there, so I think we should look into Patrick Rogers' suicide. KK has 43 years to keep singing. They picked what to believe that supported their narrative. Thank you, Lena Miles. Thank you, thank you, thank you. At the time they were talking about KK is rumored. But there's just no way that they would have given up his name because they didn't know him. So Fanning must be outed. He's coming. He's going down. Fanning's going down. I think Lank's going down. And I think Kevin Albert will be joining Procta. Is it true that Procta and his wife, are they moving? Did she, or who quit their job? Courtney quit her job, the sister. Talk about Ron Logan, the bodies are on his property. Get out of here. This is crazy. Thank you, guys. Thank you, Rebecca. Appreciate you. Those of you guys that are listening from work, appreciate you guys. And we'll catch you on the flip side. Peace. Oh, I just dropped some new information with Brian Drake, too. Brian Drake stuff's coming. I think I'm doing a marathon of the Brian Drake Dan Moore case.